Welcome to another episode of Inside Trial Minds, brought to you by the Casely Group. I'm your host, Elvis Casely. Today we have two powerhouse attorneys out of the state of Wisconsin. First up, we have Michael Karp, co-founder of Trial Lawyers of Wisconsin, known for his fearless trial advocacy, headline verdicts like a $12 million premises liability win, earning him the title of Outstanding Young Trial Lawyer. Along with him, Robert J. Welcenbach has led more than 30 jury trials, 40 appeals, and argued multiple times before the Wisconsin Supreme Court and secured landmark victories, including a $43 million class action lawsuit in the case of Moya versus Healthport Technologies. Together, they blend bold courtroom skills with sharp appellate strategy. Michael, Robert, welcome to the show. How you guys doing today?
Great. How are you?
Fantastic. Thank you guys so much for being here today. You guys are our first duo team to come out. So you guys answer the questions. Whoever wants to take it, you can take it. But let's start off with each of you telling me, or telling our viewers, how you got started. How did your career get you? How did you guys get to this point in your career?
Sure, I can start. I've been a lawyer over 25 years. I started out practicing with my dad, doing sort of everything, divorce, bankruptcy, personal injury. And just throughout the years, I really learned that I love to do trials. I love being in the courtroom. And so I've just, in the last maybe 10, 15 years, really started doing solely personal injury cases because it's what I love to do. I love being in the courtroom.
Kind of fell into this by accident. Graduated in 2017. Wasn't in love with the practice of law. I was kind of doing general practice like Bob. Come from a family of lawyers. Dad was a lawyer, uncle was a lawyer, joined their practice, and got into the personal injury work. Ended up meeting Bob shortly after that. And yeah, being in the courtroom was what really got me connected to the practice of law and representing people who have gone through something catastrophic where I feel a real connection with them and want to do them right.
Gotcha. So when you guys first met, were you guys working at different firms, or how did you guys become a team under one house?
Yeah, so we both had independent practices. We were both doing personal injury at that point. Bob had his own firm. I had my own firm. And just naturally, we were working in the same building. So our firms were housed in the same building. We'd go, we'd chat, we'd discuss cases. And I think we quickly realized that we had similar philosophies on how to work up cases. And Bob was really a mentor to me. He had a lot more experience than I did. So I was constantly kind of going to his office, picking his brain. And just
Bob said, at this point, I need a cut.
Not too far from the truth.
Always.
You wind up when you're a young lawyer working up cases that have a lot of bad facts, that there isn't a lot of money involved with it. And Bob really encouraged me to take those cases to verdict, to try them, to do a jury trial. And like everybody, I was nervous about it. I had no idea what I was doing. And Bob really helped me to, number one, give me the confidence to go do it. And number two, show me kind of the steps of this is how you work up a case. This is how you prepare for trial. And we got our first verdict together. It was a great verdict. And shortly after that, within a year, we were getting 7, 8-figure verdicts together. And now we're Trial Lawyers of Wisconsin. We've merged our firms.
Now, getting those big verdicts is not lucky, right? That takes a lot of work, but it's finding those cases. How do you guys select the right cases? Because again, you said there's a lot of bad facts involved. Sometimes there's things that one lawyer might seem like, oh, there's no case here, but the countless stories of other lawyers like, oh yeah, 11 people turned it down, we turned it into $10 million. How do you guys find these big cases?
Well, I think we find them because, just what you said, other lawyers, they just don't see the big picture. They don't see the cases that we do. Like, they want to go after the simple car crash cases, the things that make them money quickly and easily. We take on cases we know we may never see a dime on it, but we do it because it's the right thing to do. We do it for the right reasons. That person we represent's injured. They have a right to have their case heard before a jury. And we've both done cases throughout our careers where, it's not the greatest case, but our client, they deserve to have people hear their side of the story and to seek justice. And we've learned throughout the years that you can turn a mediocre case or even a bad case into a winning case if you do it right and you put in the time and you have passion to do it.
Now, when you're taking these cases and you're going forth nobly, fighting for your clients, how do you manage the pressure of, we want to do good for everybody who comes into our office, and also managing the pressure of, we have to win, or this is going to be very expensive? Like, how do you balance that out?
Yeah, I mean, I think every case is unique. I think we're very selective about what cases we bring in. We do a lot of investigation up front to make sure that it's a righteous case, it's a righteous client. I think, like a lot of good trial firms, you utilize focus groups, big data studies, you put effort into understanding your case. And so before we outlay money and we advance costs to a client, we make sure that we believe in the case and that we have good data supporting our instincts that this is one that should be tried. This is a case where there should be a big verdict involved. So we do our due diligence, and then, when you're working up a case, obviously the value a case might have early on is going to change. It's going to evolve as time goes on, as you get to do discovery, as you uncover facts. And so it's our jobs as lawyers, when something catastrophic happens, you already know it's a big case. There's very significant damages, a death involved. You know that up front, but what you don't know is, what did the defendant know? What did the insurance company know? How did they respond to the situation? Witnesses that you haven't been able to uncover or speak to, what do they have to say? And so that's when you bring the full story into the picture. And, all the way up until trial, the case is always evolving.
Yeah.
Gotcha.
And I think a lot of lawyers, they look at a case and they want to know, how much are the medical bills? How long was the treatment? We try to look at it as, if this were me that was injured, or my wife, or one of my daughters, how would I feel about that? How would that injury affect me? It's not always about how long was the medical treatment or how much are the bills. It's what happened to that person and how has their life been changed, and what can we do as trial lawyers to help them get back to what they were before this crash or this incident.
Gotcha. So preparation seems to be a big part of your practice, investigating, making sure it's the right case. Now that you've done the preparation, you've taken on the case, you're fighting for this person's justice, what happens once you get to the what's your strategy in the courtroom when everything's going on? Now that after you've taken on the case, I heard you mention focus groups.
Yeah.
Do you focus group them like as if the focus group is like the jury and you pick out people like that, or?
Yeah, so we try to do focus groups early on in the case and all throughout the case. We may run 4, 5, 6 or more focus groups for one case. So our trial preparation starts on day one when we take in that case. We're already thinking, what is this case about? How's a jury going to see this case? And what do we have to do to bring this case from our first initial contact with our client to the end result? So we're always looking at it from the lens of, what is this case going to look like at a trial? And we're thinking about that on day one.
Yeah, and to your point, you can put a lot of effort, you should put a lot of effort into doing focus groups, whether they're concept-oriented focus groups, evidence-oriented focus groups, credibility-oriented focus groups, cross-examination focus groups. You do all that stuff. But once you get to the courtroom, there's a lot of uncertainties that now turn into, okay, this is what it's actually going to be. Here's the evidence that's actually going to come in. Here's the defenses they're actually going to put forth. Here's the tone of their argument. Here's how they're cross-examining a witness. Those are things that, a lot of times we're making assumptions about what that's going to look like at trial. And so I think all good trial lawyers, you put together a game plan, you put together a blueprint, But then when the ball is snapped and you're in the game, it's about in-game adjustments, because sometimes the way you thought it was going to play out, the way you set up the chessboard, it's not the right strategy after opening statement. So it's very important that, you test your strategies, you put together the best game plan. But if your wide receiver gets injured, your star wide receiver...
Everybody has a plan till they get punched in the face.
That's a very true statement. You have to be ready to pivot.
Gotcha. Are you allowed to show depositions or anything like that to focus groups? And this, we've already interviewed, say it's a truck driver accident. Here's the interview with the truck driver. What is your perception of the attorney interviewing him? What is your perception of what liability this truck driver has? You're allowed to do that?
Absolutely.
Yeah, we just did that actually about a week ago with one of our clients. We didn't have a video deposition, but what we did is we re-interviewed her sort of in a deposition style format, and then we showed that to the focus group. And it was very interesting because, some of the people in the focus group really picked up on her body language and in the way that she responded to questions and thought it was bad, and some thought it was okay, and it was actually it made her more credible. So it is really important to do that with a focus group and see what they're picking up on, so you can get an idea of what is your witness going to look like and how can you better prepare them for the trial, because it's a stressful thing for a lawyer, for a client to be in the courtroom. So you got to make them feel comfortable, and in doing those types of prep with your client only makes them a better witness and makes them more credible.
Yeah, I'll just piggyback on that a little bit. What's interesting about when you show a focus group, you show average people that don't have any legal knowledge. They haven't had maybe any experience being a juror. They don't know how things work. You might feel really good strategically about the admissions that you were able to extract from a witness in a deposition. You might feel like you proved your case. You might feel very strong that the jury is going to feel the same way you do. And then you show a focus group, and it's interesting because a lot of people, they don't really catch on to necessarily the little legal aspects of the case. They're listening to tone. They're looking at body language. And the moments of the deposition that speak out to them may not be the same moments that speak out to you. And so it's very important to just constantly test your assumptions and understand that when you get to the courtroom, you're dealing with the judge, you're dealing with the law and the jury instructions, but ultimately you're dealing with 12 people that, let's be honest, a lot of them are not paying that close of attention to the jury instructions. They're not paying that close of attention to every little thing that the doctor said. They're taking cues from body language. They're taking cues from tone. And so it's important to be mindful of that. And you don't want to find that out at trial. You want to find that out in the focus groups.
So how do you deal with inchangeable bad facts that the focus groups keep pointing out, that going into trial, this is something that you need to nip in the bud or try to diffuse as early as possible? How do you guys deal with those?
I think it takes a lot of work, and sometimes maybe you can't get over that. Maybe it kills your case, and you have to just be realistic and be honest with your client. I think we do a really good job of trying to figure out, with that bad fact, what really has happened in this case, because there's always going to be bad facts, and so you can either try to address it. You can try to figure out, does it really change what happened? Does it really change the fact that this defendant, this person, was negligent and injured your client? No person starts out coming into that courtroom perfect. But should that deprive them of justice, this bad fact? And so we really take a look at that, and we figure out ways to either overcome it, to make it so that it doesn't really kill the case, or you deal with it head on and you're honest with the jury about it, and you just tell them this is a bad fact. What do you think about it? And you diffuse that starting in jury selection.
Yeah, and I think you always start with, it's very important to keep an open mind, because as lawyers you do this and you have all these cases and you see patterns, but each case is different, and the way that focus group participants or jurors are going to look at it is going to be different than the way you look at it. So I think one place to start is it a bad fact? You might have an initial reaction that it's a bad fact, but is it really a bad fact? Are people going to stick on it as much as you are? And so, there are obvious bad facts. If your client was drinking or they were under the influence or something, that's usually something everyone's going to look at and consider to be bad. But there are other facts that you might initially think are bad, and then when they're put into context or you hear participants in a focus group talking about it, it ends up being a good fact. And I think that's, whether it's the Mitnick philosophy, but you're always trying to understand, how do we put things in context? And if you have a bad fact, how does that fit into the overall story? And once it fits, is it still a bad fact or potentially something that helps prove your case?
Gotcha. So I want to pivot over to the actual cases that you guys have done. Michael, you had a case that started off with a $250,000 value, and you ultimately got that $12 million verdict. How did that go down? What's the story behind that?
It's a good case to talk about because when I first took that case, I was a fresh lawyer. I mean, I had just graduated law school. This is 2017, 2018, and it was a slip and fall on ice in Wisconsin. We're from the Midwest, and traditionally, most firms look at that and say, I'm not sure this is one we want to get involved in. A lot of people have the attitude that if someone slips and falls on ice in Wisconsin, that's on the person who fell, and there's really nobody to sue. There's nobody to collect from. And that's around the same time as when Bob and I began to talk and brainstorm, and I would go to him about this case, about other cases, and ask him, hey, here's what I found out. What should be my strategy going into this deposition? And so I started off kind of working it up on my own, and then we started working it up together, and it was way down the line, like maybe 6 months prior to trial. I can't remember exactly that they offered the $250. It was a $0 up until then.
So from the beginning, they didn't even want to offer.
No, we're not responsible. This is on your client. And there were a lot of bad facts, and we confirmed that they were bad facts through doing focus groups. And so we worked that up together. The $250,000 they offered would have gave the client nothing. I mean, it was basically a $0 offer. And so there was really no risk in trying it. I think the risk that all lawyers face, and maybe the fear they face, is asking for what the case is truly worth. And there were significant permanent injuries that my client had suffered. But on a case where there's contested liability and there's a lot of bad facts on the plaintiff side, a lot of lawyers, including myself, are fearful, especially if you've never done it before, to ask for $12 million on a case like that. Bob gave me the confidence to go in there and ask for what it was really worth, and he helped me do that through testing, through focus groups, which I really learned through him.
This episode is brought to you by GetCompensation.law. Injured? Confused about what to do next? Let GetCompensation.law connect you with top-tier personal injury attorneys. Fast, free, and tailored to your case. No hassle, no hidden fees, just results. Get the compensation you deserve at GetCompensation.law. I can't imagine the pressure that you both must have been under to have an offer of $250,000 and to ask for this, not $250,000 to $12 million. I'm not a math. I don't know math like that.
Yeah. Me neither.
I just know that it's way more than like 10, 20 times more.
Yeah.
That's crazy. So you're in court. You asked the jury for $12 million for your client. What was the first day of court like? Because at what point do you say how much you're fighting for? Is that the very beginning? Is that after they're like, yeah, you guys win. How much do you want? How does that go?
I mean, it depends on the case and it depends on the judge, and there's always so many depends. That's a lawyer answer. But in this particular case, we put that. We said millions of dollars in jury selection, so I think we said tens of millions of dollars, so it was clear that we were asking for a lot of money. And then in opening statement, we did give our number. I think we were shut down really quick. I think the defense objected, and the judge sustained it as being argumentative, our number. But we like to put that out there, especially in a case like that where you know that you really have to overcome this liability hurdle before you ever get to the money. We want to make sure they're not surprised at the end of the day of like, okay, we agree your client wasn't at fault. We agree that the defendant corporation was negligent, but whoa, $12 million, we were thinking 10 grand. You know? So that's number one. I think the other thing to really think about is, do you really believe in your number? You know, I think everybody likes to talk about big verdicts and everybody wants a big verdict. And certainly, you know, myself, as lawyers, we all want to maximize the value of the case, but the value has to be there. I mean, you can't make something out of nothing. Yeah, I haven't seen it done. Every case where I've seen a big number, when you look into the facts, you say, okay, yeah, there might have been some really bad facts. There might have been some really good lawyering, but there were significant damages, or the reasons for the big verdict were justified based on how the defendants defended the case or you know, lied about their defenses in court. So I was able to have the confidence because I knew the case was really worth that amount of money. And obviously, when the jury came back unanimously, we were proved right.
Well, I think it's a mindset thing too. It's, you know, if you go in listening to other lawyers and other people tell you, oh, this is a slip and fall, you're crazy to ask for more than $250,000, $300,000. You let that infect your mind. That's what you're going to do, right? So you have to be willing to look at it, like I said, from, if this were me, this is my kid, my wife, living with this. Our client had CRPS, complex regional pain syndrome, where he's in horrific pain all hours of the day. I mean, he can't even go outside in the wind. The wind, it is so painful. It's the most painful condition you can ever have. So, you know, for someone to say, well, it's worth 250, 300 grand, not if that was me, not if that was Michael, not for any of my family members. So we put ourselves in that position and really try to see from our client's perspective, what is this like? $12 million? You couldn't pay me to have that for $12 million. No way.
Yeah.
Well, and just to clarify, so in every case, there's different kinds of damages. There's economic damages like your medical bills, your lost wages, and then there's non-economic damages that is pain and suffering for the past and potentially the future if you're permanently injured. This case, we asked for $12 million for just pain and suffering. No medical bills, no wage loss, no nothing. It was just for what he's gone through and what he's going to have to go through. So sometimes you see these big numbers, and it's not to take anything away from the number itself or the work that went into getting that number, but you have to break down what were the damages, what were the asks. Were there $3 million in medical bills? Was there a $2 million life care plan? Those are things that you need to understand to really understand the verdict itself. So in a case where it's a slip and fall and you go in and you ask for purely non-economic damages, you really do need to be confident and you really do need to believe in that. Because if you get up there and you say a big number and you don't believe it, the jury's going to see through that. I mean, people are not stupid. They will look at you. They will read your body language. They will see that you don't believe it and that you're asking for a big number, and they'll send you out of there with nothing.
And then I would assume that they not just believing in you guys, but also believing in the client themselves. Because the client, in a case where it's all about pain and suffering, I'm assuming he testified?
Yes.
After big cases like this, that you win big for your clients, like you just said, you couldn't pay me $12 million to feel pain from the wind, right? Yeah. But how do they feel, or how do you perceive them to feel after they win like that? Do they feel validated? That how does that go? Well,
Obviously, no one ever wants money if they could just put themselves back in that position. I mean, this gentleman we represented, his life going forward is going to be horrific. He never wanted this to happen, and I think if you asked him, he'd say for sure he would never take that money for what he's had to go through. So I think in general, they want to be heard. They want to be validated, and they want to know that the jury sees that what they've gone through and what they're telling is the truth, and that they've been acknowledged.
I think it's about the truth. That's really what it's about, because you can say, nobody would accept millions of dollars for pain. Well, how much pain? I mean, if it's just a little bit of pain, right, and the jury's left with the impression that this is like stubbing your toe, and, would I take $12 million if it felt like stubbing my toe every day? I might, right? So it really depends on proving your case based on the truth. What is the truth? If your client gets up there and they testify honestly, and the doctors get up there and it's corroborated, and they can see the medical evidence that is consistent with the testimony, your job as a trial lawyer is to go in there and get as much evidence of the truth that you can possibly acquire, and put that in before the jury in a way that is simple for them to understand. And if that all aligns and the case is righteous, then you can get a big verdict. But it is a legitimate question. We like to drink our own Kool-Aid as trial lawyers. And it's important to ask, like, there are some injuries where if you ask for too much money, there are going to be people sitting on that jury thinking, I would take that money for that. My back hurts worse than what I'm hearing from your clients. So, that goes into witness preparation. It goes into understanding the medicine. It goes into understanding the medical records. All of that needs to be the truth for you to get to a big verdict.
Now, for new attorneys out there who are just starting out, like that was you were new when you got that case. Both of you talk a lot about understanding the medicine and whatnot. How much in depth into like knowing that information do you guys go? Because you guys are lawyers, you're not doctors, but you have to argue medical things. So are you learning all of it? Are you just focusing specifically? What are you learning?
I think you have to learn as much as you possibly can, because at the end of the day, you want to be right. You want to make sure that what your client is saying happened to him is from this accident or this injury. But I think it's so much easier nowadays with ChatGPT and these other programs to get assistance and to figure it out. I mean, you can put things into an AI program now and really understand it in a way you couldn't before. Before, you'd have to really have an expert and be able to talk to them to understand it. But you can definitely get beat on the medicine if you don't put the time in, and it's a constant struggle for us, going through medical records, understanding it, see how it fits together, making sure you have everything, and that what your client is saying is what happened, and being able to explain that in really simple terms to the jury, because you can get caught up as lawyers. Like, for instance, we did a focus group the other week, and one of the focus group members didn't know what negligence meant, didn't know what plaintiff meant, defendant. So you have to take the medicine, you have to understand it, but you have to make it really simple.
Yeah, I feel like I'd never thought about that, but I'm not a lawyer, but I spend enough time with trial lawyers like you guys that a lot of these terms I understand, even as just a regular civilian. But it never dawned on me that you could go into trial and say defendant and stuff, and people not know which one you're talking about. It's like, wait, is your case? Aren't you guys the defendants? Like, no, they're the defendants because we're going after them. Because most people, they see Law and Order. Yeah. And when they say defendant, they're talking about the person accused of whatever the crime is. But in this case, it's technically not the other way around. But from their perspective, you guys being the lawyer for an individual, not a corporation, one might think your person is the defendant. And if you don't get that out from the beginning, they're going to be confused the whole time. They're like, oh, so the defendant did all that? He's a terrible person. I don't know why you're defending him. You guys are terrible. So,
yeah, I mean, you can really think of it as there are different languages at trial. There's the legal language that you're speaking to the judge and the other side. There's the medical language that you're using when you're talking to the doctors. And then there's normal, everyday language that people who are not lawyers or doctors use. And there's also corporate language and corporate speak. And so you need to be able to translate all that for the jury. When it comes to how much effort do you put into understanding the medicine, for example, or some other complex matter if there's other experts involved, how are you going to cross-examine an expert who has spent 30 or 40 years devoting their life to being able to talk in detail about a specific subject matter without understanding it yourself. If the truth of the matter is that you have a defense doctor coming in and saying your client did not suffer the injury that the treating doctors say they did, or they're not permanently injured, when that's not the truth, how are you going to cross-examine them effectively if you don't understand where their errors in judgment are? You can't. So now it's easier than ever, and it's more inexcusable than ever not to understand it, because you have tools through AI that can take what would be 20 hours of research and 3 associates involved to 10 minutes to boil it down in a simple language that you can understand. You absolutely need to do that, or the experts will dance around you. And it's a real shame, because if the truth is that what they're saying is not truthful and it's not supported by the evidence, and you simply just don't understand it enough to be able to expose that, it's a disservice to your client.
Understood. Now, Robert, you had the case of Moya versus Healthport Technologies.
Yeah.
That was a class action lawsuit. One, how does a class action lawsuit differ in just one client versus representing all these people? And two, what happened in that case?
Yeah, so that was a case of, in Wisconsin, when you request your own medical records or you do it through a lawyer, the healthcare provider is supposed to give you those records, and they're not supposed to charge you certain fees, like a retrieval fee or a certification fee. And when you have an injury case in Wisconsin, those records need to be certified to be used in court. So what happened was these companies kept charging illegal retrieval and certification fees. Even after we said, don't do this, you're not allowed to do it, they just kept doing it. And, there's a lot of talk about it for years. And finally, I just said, this is not right. This is not right. They're not supposed to charge this, and we're going to do something about it. So we started a class action lawsuit. In a class action lawsuit, it's pretty similar to a regular lawsuit, except instead of representing one person, you represent a group of people who all have the same type of claim or the same type of injury. And so in this case, we determined that there were hundreds of thousands of people who had been overcharged for their records. And we're not talking a big amount, we're talking $30. But this is why everyone was talking about it for years. Who's gonna go and sue someone for $30? No one, right? And that's how these big companies, these corporations get away with it, because they figure, a dollar or two here or there added onto your bill. No one's gonna do anything about it. We decided to stand up and do something about it, and we recovered $43 million for the whole group of people.
How did that come to your attention? Because you said that I don't know if you meant you told them or we told them, as in like just the community. But how did that come across your desk?
Yeah, so when we represent a person who's been injured, we write to the medical provider to get a copy of their records. And then we advance that fee, right? We pay the healthcare provider to get the records. Well, they kept just charging us and sending us invoices with these illegal fees, and we'd write on it, you cannot charge this, this is not allowed. We'd send it back. They would just ignore us. They'd send us the invoice back, and basically they hold you hostage, right? You can't get your client's records unless you're going to pay them this money in advance.
So they had the audacity to do that to a lawyer,
yeah,
knowing that they were in the wrong.
Well, and what we found out, and what was even worse, is they knew what they were doing was wrong, because they actually lobbied the legislature before the law had passed, and they acknowledged that it was illegal. And this was all done behind closed doors. But no one knew about it because it was done through the lobbyists and the legislature. And once we started that case and we started taking depositions and getting medical, information and records about the lobbying, we found all these emails between the healthcare providers saying, we know we can't charge this, but we're going to say that we can, and we're going to go ahead and just do it. And that's what they did. They put out media campaigns, and they had articles written by lawyers saying you can still charge these fees, right after they'd already lobbied the legislature knowing they couldn't.
So how do they defend themselves in court when it's like, I've never understood when something is a clean cut, this is against the law situation. why are we arguing for 2 weeks, 3 months, whatever the time is in court? Why is the judge not saying, hey, this is illegal. Here's the letter of the law. You did this, case closed. Here's your money. Like, why does it take so much time to argue something that is against the law?
Because people don't want to do the right thing. They don't want to take accountability. They don't want to be responsible. And it's what we talk about a lot. It's you blame someone else, you blame something else, and if that doesn't work, you blame the lawyer. And that's what they did in that case. They tried to make this about the lawyers and that the lawyers were just greedy and the lawyers were trying to get something that's still able to be charged by them. And at the end of the day, they appealed this case multiple times, lost every single appeal, and they had to face the music. And that's why the case got settled, because they knew what they did was wrong, and we were going to hold them accountable. And that's what happened in that case.
Gotcha. So I know when you win a case and the other side appeals it, there's like an interest occurring on whatever the winnings were, or the verdict was. Is that how it got to 43, or how did you guys ultimately get to 43 through their multiple appeals?
Yeah, so these were appeals throughout the case before a judgment or a verdict was entered. So there wasn't an amount like what you were talking about. Is there's an actual judgment, and then when they appeal it, there's interest on that judgment. These were it's what they call interlocutory appeals. It's an appeal while the case is still pending. So they had lost the very first motion. They tried to dismiss the case. They lost. They tried to appeal that and got sent back, and then we won again on motions. They kept appealing it. So we never got to a judgment or verdict. And so the $43 million was really based on what the total amount was that was illegally charged. Plus, under the law that we sued on, there were what they call sort of punitive or exemplary damages, where they could have been held liable for additional amounts. So the $43 million took that into account. Their potential exposure, and that included the overcharges and those exemplary or punitive damages.
Gotcha. Shoot, they send a fee to the wrong lawyer. $30, $2 fee turned into $43 million.
They're still doing it. So
Jesus. Now, you guys, nobody bats 100, right? Is there any case that you guys, either together or individually, have lost or didn't get the verdict or settlement that you thought was appropriate? And how did you deal with that?
Yeah, recently. And it happens if you're a trial lawyer, it's going to happen. I can't get into too many details about it because it's on appeal. But the short story is we didn't get a fair shake. We went to trial, and the way evidence was dismissed, the way it turned out, we just didn't have a fair shot. And that can happen. No matter how much prep that you put in, you can get a judge that, whether intentionally or unintentionally, doesn't apply the law, doesn't treat you fairly. And when that happens, you have to understand, every time that you go to try a case, 12 people decide what happens. Sometimes the judge decides what happens before the jury gets to decide. And there's just always a risk that you could come out with nothing. And that's why with all of our clients, we always educate them, no matter how much confidence we have in our own abilities or what the focus group data or the big data is saying. We tell them, look, when you go to trial, anything can happen. It's true. Anything can happen. And that's why our clients and all clients deserve a lot of credit for taking that risk on. And many times, there's a perception, I think, that a lot of plaintiffs pursue trial because they want to hit big.
Mm-hmm.
And that has not been my experience. In almost all cases, our clients, and I think most clients, are doing it because they want the truth revealed. They want the full story told. And a lot of times, even if there's been a violation of a law, or it seems super clear cut, this was a drunk driver that hit a pedestrian. What kind of defense could be posed? But then you learn that he was drinking with his boss at work before he left, and the company was trying to shield itself. And there's more to the story that needs to be told for there to be real justice. And a lot of times clients are not necessarily motivated by money, but they're motivated by the truth being told. And so even sometimes when the judge makes a bad call, or sometimes you feel like the jury made a bad call, a lot of times clients are still satisfied and honored that they had an opportunity to go before members of the community and have their full story told. So in this most recent trial that we had, which is on appeal, we did everything that we could have possibly done. We're very proud of our performance, but there were certain things that went on that shouldn't have happened, and hopefully we're going to get to rectify that in the future.
Gotcha. On the flip side of that, are there any cases that you won that you were confident about in the beginning, but maybe closer to the end of the trial, maybe not as confident, and you've got what you wanted, the win, and you're like, I don't know where that came from, but I'm glad we won?
I think trials, you can have the best plan. You can do focus groups. You can do the big data studies. But like Michael said, they're unpredictable. Trials are unpredictable. And I think you have to, do the best prep you can and be ready for when things don't go your way to adjust to that. I can't really think of a case that I went in really thinking 100% I'm going to win. My attitude is I prepare the case as if I'm going to lose, because I want to be the most prepared person. I want to know everything that I can. I want to be ready that if this evidence doesn't come in, I can adjust. But I'm always happy when I win, but I never go in thinking, I'm never overconfident that I'm 100% going to win this case.
Gotcha. Now, after a win or a loss, do you guys debrief, run it back, take notes, or see what you can garner from that case and take forward into the next? How does the post-trial work look like?
I think, in my opinion, that's one of the most difficult and challenging aspects of being a trial lawyer, because win or lose, after every trial, you kind of see the whole world differently. At least I do. And you start to re-examine everything that you did. It can be dangerous because you can overanalyze things and think, you can put too much weight on. Maybe you felt like a certain cross-examination didn't go the way as planned, and now you're attributing a loss to that. Or even if you got a great result, it didn't feel good in the moment, but once you polled the jurors, they're like, we don't even remember that testimony. It didn't stick out to us. So it's important that you try to identify from the jurors' perspective what you think, actually swayed things if you have an opportunity to talk to them. But every single time you get finished with the trial, you're always kind of revisiting, did we like what we did in jury selection? Did we like the jury that we picked? Did we think that the way we presented the evidence was the most effective way? Did we like the sequencing of our witnesses? How did things shake out in closing argument? Did our case framing kind of pan out the way we thought? You're always looking at those things. You're always evolving. You're always learning. And that's actually, it's the most challenging thing, because you wish you could just have one established blueprint and be like, I'm just going to do this now. Here's my playbook. But really, every case needs its own playbook in a way. There's certain things you always do, but it's also one of the most fun things at the end of the trial to sort of look in the mirror and say, all right, in the next trial, what do you want to try? What do you think worked well? I don't know what you think.
Yeah, I mean, I think, they always say that you learn the most from your losses, which is true, because it's so painful. Mm-hmm. That really forces you to go back and take a look at yourself and what you've done and really analyze what can you do different, or what could you have done different to win that case. When I do a trial, I try to every break or at night, I try to go in and I try to put into my phone in my notes app or something, what I could have done different, or what I should try next time. We don't have a formal, after action plan or anything that we do, but Michael and I are constantly discussing everything depositions, discovery. How are we going to make this process better? What can we do for the next time so that either it doesn't happen to us or we do it in a better way? And I think if you're not doing that work, you're not challenging yourself, you're not thinking about that, you're going to stagnate. That's the way you get better as a lawyer, is constantly trying to figure out how you can do better, what you can do different, and get the best result for your client that way.
Gotcha. Now, moving on to the industry as a whole, you mentioned earlier the use of AI. It's become very prominent. I know I've gone to quite a few of these trial lawyer conventions, and there's at least 3-4 panels all the time of our AI software does this, or this is how our law firm uses AI. And then there's vendors selling AI file organizers, AI intake. What is y'all's take on the use of AI in the legal sphere, and how it can be misused or how it's used properly? What do you guys say?
You want to go?
I think there's a lot of shiny object syndrome. I think there are a lot of great tools out there, but you can also get totally distracted with trying each new tool and, just getting carried away with that. I think mostly, you're starting with first principles. You're asking, is this a technology that can help us be more effective or more efficient, or put on a better case? And then you ask, how can we do that? How do we utilize it? So there are certain things where I think it can augment what you're doing. For example, if you're trying to learn the medicine more efficiently than just Google searching or reading, medical literature online, you can have it, AI break down the complicated medical terminology in words that a 5-year-old would understand. There's like easy, low-hanging fruit use cases like that. What I do see happening is I see a lot of lawyers over-relying on the AI and saying, create me a deposition outline. Okay. You don't want to delegate entirely the job, because and I don't think AI is ever going to be fully capable of doing that, because there's a level of creativity and adaptability during the deposition that needs to be there to be a really effective trial lawyer. So I would say, are there tools out there that are exciting, that offer efficiency that hasn't ever been there before? Yes. Is there organization tools and all of that? Yes. Are those things going to get implemented? They are. But I would be very careful about what technology you're bringing in and how much you're relying on it, to make sure you're not missing that magic little space that actually makes a difference in trial, that really right now I don't see AI being able to detect.
We're not going to have iRobot Esquire trying cases.
Yeah, I mean, there's even deposition tools that will generate follow-up questions and stuff during a deposition. Do I think that stuff is useful? Yes, but it also makes me pause, because I don't think the AI, for example, is going to be as good as a experienced mentor that's telling you, hey, look, here's what I would have asked and here's why I would have asked it. A simple follow-up that, a missed factual inquiry or something like that. Can it be useful? Yeah, but I don't think it's a replacement for...
And I would think there's when you're talking to somebody, it's not just the words that come out of their mouth that factor into a potential follow-up question. If you ask them, hey, were you on your phone while you were driving? And they say no, but they say no, they shift in their seat before answering. It's like, okay, I'm going to start digging there.
Right.
AI reads no. Okay. Right. Moves on to the next question.
Right.
Well, and I think that's one of the things, is that you can't blindly just use AI. I mean, that doesn't, that's not a substitute for doing the hard work and the thought process. In your example, maybe you don't want to ask that question. Maybe you want to save that for trial. There's different strategies, and like you said, the AI is just going to tell you what it thinks to do. It doesn't have necessarily that strategy that you have. But there certainly are a lot of tools now that make it easier and helpful. Like you could be in a deposition and maybe an expert says something, you could put in ChatGPT, well, based on this, what is, we had one the other day. The doctor said, well, they didn't really have symptoms of this neck injury. And you can type in, what type of pain would someone have from a C3 facet syndrome? And it's going to pop up and tell you right there. It's so quick, so easy to learn that stuff. But it doesn't take the place of you going through those records, understanding it yourself, and knowing what's in there and how to ask those right questions.
And then arguing it before a jury.
Yeah.
Now, for new attorneys who are in law school right now, they pick up a sniff of our show. They're watching you guys right now. What advice would you give to them when it comes to AI? Because there's no way to get every law school to like ban AI, because at this point, no industry can ban AI, even universities. What advice would you give to them in school right now, having AI at their fingertips and choosing whether or not to use it while trying to learn to become lawyers like you guys?
I would, personally, I would use it as more of a study aid than a replacement. I'd want to know, if you're studying torts where you're talking about negligence and who did something wrong, ask it a broad question. What is the law on, something in your state about, this certain topic? But it's not a replacement for going and reading the actual cases. Because even AI, it'll tell you things that aren't true. It'll tell you this case stands for this proposition or it's about this. And when you look at that case, it's not 100%, that's what it's saying. So you gotta really go to those source cases and really figure that out. But it's a great tool to have a general background and understanding of the concepts.
Yeah, I would say, what kind of lawyer do you want to be? You want to be an average lawyer, or you want to be an amazing lawyer? You want to be an elite lawyer. If you want to be an elite lawyer, then you need to understand when you're looking at the output, what were the inputs? Because the output is going to be based on the inputs. And if you don't really understand what the instructions were for the AI, or you don't understand how it was compiling the result, you're not really going to be able to, at a high level, understand what it's producing for you. So I would say, everyone's looking for hacks in law school. There was I forgot the name of it, Cliff Notes and stuff to understand cases.
I remember Cliff Notes.
I can't, there was a legal specific Cliff Notes for cases, but yes, that stuff is useful. It is not a substitute for becoming an elite lawyer. And maybe I'm wrong. Maybe someone is going to go out there and they're going to become the next great trial lawyer and they're going to say, I did everything on AI, and I'll keep an open mind. But just from my experience, I think it's more of it's an aid, not a replacement.
Yeah, I've seen the most acceptable use of it that I've seen when it comes to any form of schooling is more so like an index or the first page in books, the book of context or whatever.
Table of contents, sure.
A table of context. It's like, okay, I have this book right here. I know the information's in here, but I don't want to flip through 200 pages. Where in this book can I find this? And then it'll tell you, and here are the bullet points, and you'll find this on that page. And then you go forth and read it. So it's more of I've seen that's the most acceptable way of learning while using AI that I've seen. Would you guys agree?
Yeah, we use it all the time for when we're in a deposition. What we'll do is we have a couple different AI programs we'll use, but one of them that we use a lot during depositions, you can go in and put all the prior depositions in or whatever you want, medical records, research, and have it just search, while you're in the deposition, say, what did witness XYZ say about this topic? And it'll just pull it right up for you with the page and line number, and you can go right there, look at the depo. It makes it so much easier to find, impeachment testimony or just to learn what people have said in your case.
Yeah, I think that's a really good use case. That's a low-hanging fruit. The worries I have over it, or the cautions that I have are, let's say you have 10 different depositions, you have 10 different witnesses. I want to know the consistencies or the inconsistencies about how they testified on a specific topic. Okay, Now you're going to scan all those depositions, and it's going to create some type of summary for you on this witness said this witness said this, etc. Well, again, it's not perfect, right? It's selecting based on its own parameters what to produce for you and show you are the consistencies or the inconsistencies. So if you haven't taken the time to review those depositions and you're not familiar, you're not going to be able to spot what it missed.
Yeah.
Right. So it's good for a quick, give me a quick at a glance view of what's going on. Is it great for, I'm going to just rely on this solely and I'm not going to actually read every line of the deposition? No.
Yeah, there's been plenty of times where I've used ChatGPT for something that I know. Like, I know the answer. I just want it to write it out. And then I'll see something missing. I'm like, what about this? And it'll go, thank you for pointing that out.
Yeah,
You're
exactly.
absolutely right. I completely forgot to mention that.
Right.
My apologies. Would you like me to revise the list, including the new information?
Right.
So you're 100% correct. You won't know what's missing if you don't know the content to begin with.
Right.
Right. Or if you over rely on it and it hallucinates and it says witness said X, Y, Z, and they never said that. And a lot of lawyers, depending on your configuration for ChatGPT or whatever, it's going to imagine things that aren't there. And we all know, we've seen embarrassing stories about lawyers filing briefs with cases that don't exist. And it's like funny, but it's not funny, because it's like that's why you really still need to know what you're doing. And double check, like, hey, is this actually right? And make sure the configurations, like, know enough about the technology that you're using so that you understand what is it pulling from. And is it using any type of creativity, or is it strictly giving me sources from what I gave it?
Yeah, I mean, it's a great research tool, but I would never file a brief with a ChatGPT case unless I've gone to that case and actually read it and know that that's what it says. I think when it comes to AI, it's trust but verify.
Yeah.
Gotcha. So you guys are a team at your firm. Do you have more members in your firm? How many people are on your team?
So we have one associate and we have 2 legal assistants at the moment, and that's because we turn 9 out of 10 cases away. We're very selective about what cases we take on, and that's just part of our overall mission. We don't want a huge docket. We're not a high volume firm. We are a trial firm, and we want to believe in the cases that we take in. We talked early on about, well, if you're spending a ton of money and time into something, money, you can make more money. If you lose money, that's one thing. You lose time, you're never getting that time back. And certainly, I don't ever want to spend 3 to 5, maybe more years devoting my life, taking time away from my family, my marriage, to be working on something that I don't believe in. I'm not here to just make money. Some firms are in that for a business. Every firm's a business, but this is a profession for us, and it's a spiritual thing for me. I mean, when I get involved in there's been a wrongful death in a family, and they come to me, they call me and say, I want you to help me. I want justice. I want closure. I don't take it lightly. And a lot of lawyers say that, and I believe them, because I see the kind of work that they put in. So I can't give that same promise to 1,000 people, not without being dishonest. So, we have a small staff right now. We will hire in the future, but we won't do so ever at the expense of our core mission, which is Bob and I personally want to make sure that when someone signs with us, we're giving them everything we got.
Yeah, and we both came from our own firms where we were each handling, I think, over 100 cases each.
Yep.
And what we decided to do was to take those cases, and we have someone else now that we've set up to handle those cases, and we've really selected the 15, 20 that we really believe in, that we want to devote all our time and our energy to. And and like you were saying, staffing, it's always an issue. We have great staff right now, and it's always something that it starts with you, it starts with your staff, it starts with your mindset about your client and what you're going to do for them. Are you going to handle 1,000 cases and you're going to dump it on a paralegal, or are you going to know everything that's going on in that case and talk to your client and be able to talk to them and tell them, yeah, this is what's going on, this is what we've done, and be able to know what's going on in those cases. So that's just the decision that we've taken, that we want to devote our time and energy to those cases and those clients, and do the best we can for them. You know, they're not just a number.
Gotcha. So we're coming up on our last 5 minutes of the show, give or take. I'm really bad at keeping track of time. But I like to devote the last few minutes of our show to opening up the floor to you guys. What is something that you guys feel the legal world should know, or whether it be new attorneys, younger attorneys, or people just out there watching lawyers talk on a podcast and have nothing to do with the law? Open the floor to you guys.
I would say, coming from personal experience, I didn't like law school. I didn't enjoy law school. I didn't know that I wanted to be a lawyer. It felt empty to me. I didn't see the meaning behind it. It felt kind of just like doing any other profession. And again, I think there's lots of different ways to have an impact in the law. Being a personal injury trial lawyer is not the only way, but it's one way that is very, very meaningful. It's one way you can make a lot of money, and that attracts a lot of people to it, but you get to do a lot of good for the world. And I think that's something people are desperate for in today's world, is like, I want to find something where when I go to work every day, it's not simply to pay the bills. It's not simply to carry on my lifestyle. It's something that when it's all said and done, I can look back on my life and feel like I made a real impact, that I changed people's lives for the better, that I changed the world for the better. And so if you're a law student or you're considering a career in law, as scary as it sounds, as much work is involved in being a trial lawyer, it's going to be worth it if you want to go down that path. You get to do amazing things that will fulfill you, not just financially, but spiritually. And that's something that you should really consider.
Excellent.
I would just say, if you're a young lawyer, there's no better time than now to become a great lawyer, no matter what area you want to be in. But for a trial lawyer, there are so many resources. You have all these things online now. Like 25 years ago, when I was out there, you could order a book online and maybe get some trial strategy. Now you can go online. You can learn all of this stuff. And there's so many resources. There's so many people that are willing to help you, that if you want to become a great trial lawyer and you make up that decision in your mind, it's very easy to do that. But you have to be willing to put in the time and the effort. So I would say, if that's what you're interested in, do that. Take those steps. You know, being a trial lawyer, I think, can be a stressful profession. But I think if you find those people and that support, it can be one of the most rewarding things.
Excellent. Thank you guys so much. It's been a great conversation between the two of you.
Yep.
Thanks for being here.
Pleasure to be here.
Thank you guys for tuning in to another episode of Inside Trial Minds. Thank you to our awesome guests. You guys out there, stay hungry, stay focused, and tune in next time as we dive deep into another Trial Mind.